The register statement. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 569. SCAO for State Court Administrative Office, PC for Probate Court, Form 569, the register statement. If you need this form, we're happy to give it to you free of charge. The SCAO form is used specifically when somebody has died and you're going through probate administration. Now, this is a particular type of probate administration because, of course, you can choose between a formal process and an informal probate. This is for the informal process, meaning you've used an application to open the estate rather than a petition. And it's really important to understand the difference between an informal probate and a probate that is done with formality or with supervision. The big differences relate to the adjudications by the judge. So for example, in a formal administration, there's an order that determines heirs. It's done by court order. A will, if brought to the court, would be admitted and allowed by the court. In an informal administration, none of this occurs. So the idea of informal administration is when the family is in great harmony. Everyone's getting along well. There's not much complexity. You don't need the court's intervention in the administration. And most of the administration is done without or with almost no court intervention or involvement. So it's really important to decide which path you need to go. Because if you go informal, you're not having court oversight each step of the way. So again, with all of these court forms, they are created by various statutes and court rules. And understanding those statutes and court rules is really critical to know how to navigate through the probate process. And I strongly urge you, like I would with any type of legal matter, is to be working with a skilled, competent probate lawyer to guide you through these various statutes and court rules and to help you decide which way to navigate. As you can see from this particular SCAO form, there are a lot of statutes and court rules here that are identified by that floating yellow arrow. Now, there's a lot of them because it addresses all of the issues relating to the informal probate administration process. Let's work our way through the document. At the top, pretty straightforward, the county and the case number. And usually when you file this, you may not even have a case number at that time. You're going to identify the estate name, pretty easy, the person that died. And then, of course, under number 1, you're identifying that you have filed an application for informal probate. And you are either asking for informal probate of the will, that's checkbox 1, and it could be and or, the appointment of a personal representative. And if the estate is being reopened, then the previously administered estate be reopened, and that the or the appointment of a successor, meaning a new personal representative. So again, a few check boxes to choose from here. But again, important to note, this register statement only occurs in informal probate administration. Number 2 is you're asserting that upon consideration of the application, the following things have been deemed to be true. And this, of course, is signed by the registrar. So this is the registrar that's actually making these statements. Venue is proper, which means that the county upon which this matter is proceeding is appropriate. The application was done correctly under the statute 700.3301, as well as the court rule MCR 5.312. The applicant appears to be an interested person, meaning not anyone can just go open an estate. You have to have standing or to be an interested person to be able to do so. Then, of course, the next section relates to whether there's a will or codicil, as well as whether there's an authenticated copy of the will or codicil. So again, some nuances depending on whether it's intestate without a will or testate with a will. Section E indicates that the application is not within that particular statute, which is a carve-out for its use. Section F provides that if the will specifically says informal or formal probate, not all that common for it to occur, but some will specifically direct formal or informal or supervised or unsupervised or a bond or no bond. So sometimes it's contained within a will. Section G speaks about that the person sought in the application has the priority for the appointment. So this provision there's a pecking order for the appointment of a personal representative. And if you have the highest priority, or if you have renunciations from those of equal or higher priority, it allows the registrar to do that appointment as long as things are correct without the necessity of a court hearing and adjudication. Now, in addition, you could use the notice of intent process rather than the submission of the application with renunciations. The notice of intent process is guided by statute, and again, it's very particular about how you give notice to anyone of equal or higher priority of appointment to have them passively assent to that application by taking no action. Of course, they can object and say that they don't want the informal probate. Again, I'm giving you a broad understanding. There are lots of nuances relating to the administration and the rules relating to it. In addition, there's a provision that allows for good cause if the probate estate needs to be reopened and the appointment of a personal representative to occur. And again, number 3 speaks about the admission for informal probate of a will. And again, really important to understand that the admission informally of a will is very different than a formal admission of a will, and what it means and how it binds the actions thereafter. It's really important to understand the difference. Section 4 identifies who's getting appointed, whether they're appointed personal representative, special personal representative, or successor. Again, different terms, different fiduciary hats. Successor just simply means you're following somebody. Special is a particular type of role as defined by statute and court rule. In addition, whether there's a bond requirement or no bond, and a bond is a guarantee of the performance of that personal representative. Section 5 speaks about the denial of the application because of certain reasons. So the registrar can check those boxes in the event that the application for informal probate that was submitted is now being denied by the registrar. Section 6 provides for if the estate is being reopened, and then there's a checkbox for an expiration of the letters of authority. And again, usually these are yearly letters of authority, but the court can change the terms and put additional restrictions relative to the letters of authority. There's a spot for the court registrar to sign, as well as if there's an attorney to fill in the information there. Again, a broad paintbrush picture of how this register statement is completed. It's generally completed when you're submitting the application for informal probate with the testimony and related documents, so that the registrar can make a decision based on the application as presented. At the Probate Pro, we're passionate about everything probate. If you have questions about the register statement or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.